Right, hello everybody, and welcome to another vlog from the PI and ClinNeg groups at number 5 Chambers. Today we're going to discuss our immediate reactions to the decision of the Court of Appeal in Swift and Carpenter. A health warning first, this vlog was recorded on Sunday the 11th of October, a mere 2 days after the judgment in Swift was handed down. So it very much reflects our immediate reactions to the judgment, and we're conscious that it may not age particularly well, but we're not going to let that stop us. We're just going to dive in anyway and tell you what we think as best we can. Let me just recap the background to the appeal in Swift. Before I do that, actually, let me introduce the other lovely people you'll be able to see on the screen with me. Welcoming back Mr. Henry Pitchers, QC, who I don't seem to be able to get off these vlogs. I think you've been on every one so far, but we're trying our best. Mr. Matthew Brunning, hello. And last but certainly not least, Lois Norris. How are you, Lois?
Hi, all good.
Good. All right. So the background, as I'm sure many of you watching will know already, but just to recap, Swift was an appeal of a first instance judgment where Mrs. Justice Lambert awarded nothing to an injured claimant for the damages for the capital costs of accommodation to an amputee that she was accepted she reasonably needed as a result of her injury. The reason that Mrs. Justice Lambert did that was because she considered herself bound by the authority of Roberts and Johnson, which since about 1989 has provided the manner in which accommodation costs, certainly as far as capital costs of accommodation are concerned, are calculated in these sort of cases. The difficulty that Roberts and Johnson was trying to address in the way that it did that calculation of those losses was the risk of a windfall to a claimant, or more likely to his or her estate. Because if a claimant is simply awarded the full capital cost or increased costs of getting a new house, then that is a capital asset, that house, which will remain there on their death to be sold, and representing a windfall to their estate. It's important to know what we're talking about here is the capital costs of accommodation, not adaptation costs, which you might need as a result of an injury, which is something different. And so far as we're concerned, we may touch on this later, have remained calculated and probably still remain calculated in the usual way in terms of what that costs someone. So the difficulty Roberts and Johnson was trying to wrestle with was the fact that if you bought a house for somebody as a result of their injury, they would still have that house, which would still be worth at least what they paid for it, and often would increase in value over the course of their lifetime. So it wasn't really a loss as such. The way the Court of Appeal and Roberts and Johnson decided to address that difficulty was to compensate the claimant in effect for the inability to invest the capital sum that they were having to tie up in that accommodation by buying that house. So they were not able to invest that in some other way and get a rate of return on it. And the way that was calculated, certainly from when it fell in line with the discount rate in around 2001, was to say that if you could invest that money, you'd get what the discount rate was, 2.5% interest on that a year. And so your loss as a claimant was 2.5% a year of the capital value or an increased capital value of your accommodation for the rest of your life, calculated in the usual multiplicand way. The difficulty with that, and there was quite a lot of criticism of Roberts and Johnson and that approach even before we got into the era of negative discounts rates, because the difficulty often was, and I think we all found this in our own cases, was that it would often produce a sum by doing that calculation, which was not enough in some cases for claimants to buy the accommodation that they needed. And certainly it was very common for claimants to have to effectively borrow damages from their general damages or other heads of loss to fund the accommodation and make up the shortfall between what they got under the Roberts and Johnson calculation and what they actually needed to buy a house. In the era of negative discount rates, things became even worse because, of course, if the position is you can't get a return on your money, then you're not losing anything by not being able to invest it. And the result is if you multiply a certain amount per year by a negative amount, you get zero at best. So That's what happened at first instance in Swift. So in Swift at first instance, Mr. Justice Lambert said, I'm bound by Roberts and Johnson. And when we have a negative discount rate, as we do at the moment, that produces nothing for the capital costs of accommodation that everybody accepts this claimant needs. So that was appealed to the Court of Appeal on that issue, whether Robert and Johnson was still the right way to approach these sorts of calculations in an era of negative discount rates, with the appellant claimant suggesting that a new approach was required. Henry, I think perhaps if we go to you at that point, do you want to talk us through what the Court of Appeal did with that conundrum and how they decided to sort it out?
Yeah, I mean, so the short answer is the claimant was awarded damages of £801,913 against an identified capital need of 900,000. I suspect you want a little bit more of a breakdown on the ratio than that. Yeah, okay. I think
we can stop now if you like, but it may be that people are interested in how they did it. Yeah.
So I think perhaps the first thing to note about it is that of the various solutions that we mooted and had been talked about, not just in the first instance of Swift, but also those of us who were doing articles and seminars, of those various solutions, most of them were abandoned completely. And many of them were disposed of very quickly. So you can forget about all that discussion about the cost of interest-only mortgages, getting loans from insurance companies, notional rental costs, defendants buying properties for claimants. So those possible solutions fell very quickly by the wayside. And the first question that the Court of Appeal asked itself was whether actually it remained bound to follow the approach in Roberts and Johnson, which Jamie summarised to you. And in answering that question, the court identified a distinction between matters of legal principle and matters of judicial guidance. And putting it bluntly, if the Roberts and Johnson approach was an established legal principle, it would operate in the normal way in accordance with the rules of precedent, subject to the powers of the court to make a subsequent decision differently or to overrule itself. So, however, they held that judicial guidance could properly be revisited if the existing social or economic circumstances were such that it was now inconsistent with achieving the relevant legal principles of law. So, as a result, the Court of Appeal determined that the approach in Roberts and Johnson was guidance only, not binding legal precedent upon them. And they felt that it no longer served the purposes. The two principal applicable principles of law they identified were firstly that a claimant who's injured by the fault of another is entitled to fair and reasonable, but not excessive compensation. And secondly, that an award of damages should seek as far as possible to avoid a windfall to a claimant or his or her estate. So having concluded that the guidance in Roberts and Johnson no longer worked, the court set about coming up with an alternative methodology. Most fundamentally, the court did not accept the arguments that were put forward on behalf of the defendants, the respondents to the appeal, which was in part that a claimant who's borrowed from other heads of loss to fund the accommodation outlay can recoup and fund any shortfall by an equity release in old age. And that was given relatively short shrift by the Court of Appeal. Rather, they decided that a new methodology was appropriate and that a claimant should be entitled to the capital cost of the larger or improved property, less the value of the reversionary interest. Now, I suspect that many of us who've elected to pursue a career in personal injury or clinical negligence did so as to avoid having to consider issues of trust law, which I certainly left behind at university. But we're going to have to sort of get our head around it to some extent. So a reversionary interest in a property is an interest which will revert to its owner at the expiry of an agreement. And typically, this arises where a deceased provides a life tenancy to a surviving spouse with the children of the family holding the reversionary interest. So the spouse can remain living in the property, and when they die, the property reverts to the children, and that is their reversionary interest. So in a sense, in our situation, what we're looking at is the reversionary interest when the property reverts back in X years' time after the claimant dies. And to calculate that value, you have to assume an annual rate of return on that investment for each year of the remaining life. And it turns out there is a small commercial market for the purchase of these reversionary interests, and the court was provided with evidence about the sort of returns that might be expected, but ultimately took what they described as a cautious approach, which is that we should work on the basis the appropriate return is 5%. So the amount to be deducted from the additional capital element is the value of the reversion interest, which we work out based upon a 5% market value over the claimant's lifetime.
Okay, thank you. Obviously, what we need to think about in terms of that, whilst there's an awful lot in the judgment, isn't there? It's 60 odd pages long and we've all read it. And the important thing, though, at the end for most practitioners is going to be how you actually do that calculation, what the final decision is, not all the lengthy discussions of all the expert evidence that was considered at the actual hearing. I think, Matt, coming to you, the first thing to say about that is the practical effect of the Court of Appeal's decision, it seems to me, is that you will not need expert evidence in most cases from an IFA or an accountant. They've given us a formula, essentially, that Henry set out the rationale for, that we can apply to most cases, at least, without the need for that sort of expert evidence. That's right, isn't it?
Absolutely, and that was part of the Court of Appeal's rationale for departing from the methodology that the respondent sought to urge on them, because the respondent conceded that would have required actuarial evidence in every case. And given that very few cases end up going to trial, the cost and delay, the attractions of certainty and a relative rule of thumb were recognised in the judgments both of Lord Justice Irwin and Lord Justice Underhill.
Fab. So do you want to talk us through, do you want to talk us through the actual calculation that we all need to know then, and how you think we can best apply that?
Absolutely. And I say at the outset here, I'm very grateful to Darrell Allen and Richard Whitehall, who acted for PIBA and sent round with the judgment an idiot's guide, at least this idiot can understand it, for how to calculate it. So here we have on the screen now, hopefully. Does that come up?
It has.
Fabulous. Here we have the lovely calculation. So first thing we need to work out is the value of the reversionary interest, how much the claimant is giving credit for the additional property that is being funded by the defendant during her lifetime. So reversionary interest is the value of the property now required, less the value of the property B that she would have owned but for the accident, times 5% or 1.05 to the power of minus her the multiplier for her life expectancy. So there we have the calculation set out very helpfully as to the reversionary interest. I'm now going to show you how that fits into a little spreadsheet that I made earlier, because I have nothing better to do on a Sunday than that. And the calculation that was put forward in Darrell and Richard's paper relates to what I've called new property cost. And so here we see new property cost less the but-for property value. There's the life multiplier. And so the damages are the new property cost, where it was 2.35 million, less the cost of 1.45 million, the value of Mrs. Swift's exiting home, times 1.05 to the power of minus 45.43, gives a reversionary interest of £98,087. And so if we calculate the reversionary interest using that formula, we get damages of 2.35 million, less the existing costs, less the reversionary interest, giving us £801,913, as Henry set out. One point that wasn't dealt with in Swift, and we know occurs in a number of adaptation cases, is that the value of the adapted house, by virtue of the adaptations, increases above the purchase cost. And the issue, or an issue that remains to be decided, is how best that can be given credit for.
That's what people call betterment, isn't it, normally, Matt? Yeah.
Precisely that, yes. So under the Robertson-Johnson calculation, we just gave credit for that as a straight figure against the capital cost. We are valuing something very different here. We're valuing the notional enhancement in value at the end of the claimant's life, for which she ought to give credit. And I suggest, with reference to nobody else, so nobody else is got their head on the block for this one, that if the property value of Mrs. Swift's property had been increased by 150,000 to 2.5 million, then that higher value ought to be used to calculate the reversionary interest. So in those circumstances, rather than 98,000 and a few pounds, it would be a little over 114,000. But in calculating the damages, we would still take the difference in cost, which is what is being funded, less the new reversionary interest. So in this example, I think the correct approach would be, or the correct result would be, rather than recovering 801,000, recover £785,000 odd. So it's yet to be determined, but I think that rationally is the correct approach to take.
I was going to say, so essentially you're using the betterment to work out the increased value of the property, and therefore you increase the reversionary value, which increases the deduction for the claimant, and that's how the betterment is factored in, and it wouldn't require any other credit or calculation, would it, if that method was adopted?
I think that's right. One is looking at really the offset, the additional benefit that the claimant might be getting for the money that the defendant is paying. And so if the defendant's extra money which they are paying for adaptations, is resulting in an increased value on death, which is when we're calculating reversionary interest, the credit must be given by the claimant somehow, I think.
Yeah, certainly seems logical to me. Thank you. Great, that's really helpful, Matt. Thank you very much for that. I think as well as they don't deal with that, as we've said, in the judgment, do they? So that's very much our view of how you would do it rather than, or your view of how you would do it rather than something that's in the judgment. What they do, Lois, say in the judgment, though, is that there are some other cases, particularly involving claimants with short life expectancies or very short life expectancies, which can often be the case in these sort of catastrophic cases, where there are problems with this approach. Do you want to just talk us through that?
Yeah, absolutely. So in the case of Swift, the claimant's life expectancy was about 45 years. And throughout the judgment, it's clear that the court have made their decision based upon a long life expectancy case. So it's what happens in a short life expectancy case, really. And at paragraph 171 of the judgment, Erwin LJ refers to an example, a case where there's a life expectancy of 7 years and where it's not appropriate for the claimant to rent. And in that example, we can see that if the property difference is £250,000, obviously in Swift it was 900,000, then the claimant's remaining interest is only 72,300 and something, approximately 29% of the overall amount. In Swift, in contrast, the claimant's interest amounts to about 89%. The judgment tells us that the evidence of the government actuary is that the average span of a PI case is about 43 years for future life expectancy. So it may well be right that there's not a lot of short life expectancy cases in the main. But obviously, you still need to consider what you'd do if you are faced with one of those. And again, Owen LJ notes that it might be that different considerations and arguments could be applied to that category of case, albeit he makes no further comments on it because it's not before them. Again, Underhill also commented that cases involving short life expectancy may require a different approach. And it remains to be seen, really, what approach claimant practitioners and defendant practitioners will take to short life expectancy cases. It's going to be that this method probably doesn't fit. For claimant practitioners, they may be looking at the full capital value or a marginal discount. For defendants, it may be that this is the formula that's in front of us at the moment, and therefore they'd be advancing that. But it's clear in the main that this probably isn't going to fit for absolutely every case.
I wondered if actually what we saw there was avoiding an issue to maintain consensus. The impression I got was that Underhill and Irwin took very different views about the relative merits of full capital value and decided expressly to park that for another day and an appropriate case.
Yeah, maybe so. It's tricky to know, though, isn't it, where that leaves us? Because for me, where do you draw the line between what is a short life expectancy case and what isn't? Is it 7 years? Is it 15 years? Is it, where do you draw that line? And then, as Lois has said, what do you do if everyone agrees this is, in inverted commas, a short life expectancy case? What approach do you take? I mean, as Lois said, defendants, this is the one situation where this judgment works quite well for them, because I think we would probably all agree that generally it's fairly good results for claimants in a longer life expectancy case, certainly compared to the previous Roberts and Johnson, even before we got a negative discount rate. But defendants might say, well, let's stick to the Swift formula. Claimants are going to be trying to argue that it's clear from the judgment that it doesn't apply in those cases. Well, if it doesn't apply, what does apply? And it's hard not to see one of those cases potentially ending up in the higher appeal courts at some point as well, isn't it?
Yes, I think so. And I think it just depends whether practitioners take a pragmatic approach, but there's certainly a lack of guidance at the moment. So it's hard to say what that even will be.
Yeah, I mean, the other tricky bit, the other area where it seems to me there is a bit of a lack of guidance is what you do in rental situations, because it's pretty clear from the judgment that the court accepted that for most cases, and this would accord, I think, probably with all of our experiences, in most cases, renting isn't really a good option for a catastrophically injured claimant in terms of what they can do with adaptations and security of tenure and all the rest of it. But if you're in a situation where your client otherwise probably would have rented for the remainder of their lives rather than having a house that they can set off against the new house, do you simply add up the total rent they would have paid for the rest of their lives and put it into the calculation? What if that ends up producing a much higher figure than equivalent capital value of the house that they were living in? It's all a little bit unclear. What do you think, Henry?
Well, I think the difficulty would be, of course, if you had a youngish claimant who, for whatever reason, was considered likely to remain in rented accommodation. As you say, if what you give credit for is the projected rent they would have spent, but for the injuries, that could end up virtually extinguishing the capital amount. So it doesn't seem to me that this current formula is going to sit very well with a case where, as a matter of fact, the court concludes that the claimant would have continued renting. Certainly, it's not dealt with explicitly, and it's I think it's quite easy to think of cases where it would produce a rather anomalous result.
The other bit of uncertainty that remains, as I understand it, Lois, is that your word on the grapevine is it's likely that this Court of Appeal decision is going to be attempted, at least, to be appealed to the Supreme Court. So if permission's given for that, there may be a period here where we have further uncertainty about how we should approach these cases tactically, depending on which side of them we're on, awaiting what the Supreme Court might make of this. What have you heard about that?
Yeah, absolutely. And I'm relying on the Twitter sphere here, but it seems that the respondent is going to be seeking permission to appeal to the Supreme Court, or certainly that's indicated, although the basis of the same obviously isn't known yet. Until then, I think, and in long life expectancy cases, I would expect that claimant practitioners will only be proceeding on the basis of this Court of Appeal case. And indeed, if matters need to go to approval hearings, that's surely where the courts are going to be looking as well. For defendant practitioners, how to approach the matter is a little trickier. Obviously, as we said, in short life expectancy cases, the value of the reversionary interest is greater. But in those cases, the claimant may well be arguing for a different method anyway. In long life expectancy cases, it may be that these cases have already been put on hold while the discount rate changed or whilst we awaited the judgment in Swift. But I can see that defendant practitioners may certainly try and advance a different argument if permission to appeal is granted.
Yeah, they might depend on the case a bit, won't it, and how much of a difference it makes to your settlement parameters generally, it seems to me. But in cases where it may make a big difference or there's a large claim, one could see defendants saying, well, this shouldn't be determined until this has got to the Supreme Court, when claimant practitioners might be keen to say, well, this is the law of land, you've got to apply it as it is now. Any thoughts on that or anything else, Henry?
Yeah.
I noticed you managed to get through your whole discussion of precedent without saying any Latin. You don't want to have a go at that now for everybody's entertainment?
That's spooky, Jamie, because actually I've got 3 points to make just on the point about the appeal. It seemed to me perhaps the defendant's best way in would be to look at this question of staris decisis. Please don't write in if I've mispronounced.
I'm sure
Latin.
that's wrong, but carry on.
Yeah. Because that was, that's an interesting argument, isn't it, about what amounts to a legal principle and what becomes authoritative guidance, and how those should be treated differently when it comes to the law of precedent. And that might be their way of opening the door to the Supreme Court. I think the second point would be that I certainly wouldn't assume that the Supreme Court will resolve issues and the problems surrounding the short life cases. It's not been, they really haven't gone into it at all in the 66 odd pages of the judgment of the Court of Appeal. So, and of course they heard extensive evidence. So I'm not sure that we'll get answers to those questions if we do have a Supreme Court decision. And in terms of what happens between now and any appeal being heard, I guess the reality is that in many of these cases, the claimant will be a protected party, so approval will be required. So whatever attempt the parties make to come to some sort of compromise, it's going to have to be one that would meet the approval of the court.
Yeah, I think my view would be at the moment it'd be quite hard to get approval for a settlement that wasn't on the basis of a SWIFT type calculation in a longer life expectancy case. But remains to be seen, I suppose. All right, well, thank you all very much for that. I just want to thank my guests, Henry, Lois, and Matt. Thank you all for watching. Until the next time, we'll say goodbye. Thank you.